Hello, welcome to my 11th session of Arbitration Boot Camp. I certainly had no idea when I started out on this journey that I would have so much fodder for sessions, and I still have a lot of ideas. But if you have any ideas that I haven't covered and there are things you'd like to know about, please do send me an email directly, and I'll cover them in a future session. My purpose generally of these arbitration boot camp sessions, if you haven't participated before, is to kind of demystify some arbitration concepts that get talked about a lot and that you see in textbooks and case law, and apply them practically, and to provide you with some resources that allow you to use them in your practice. Just if you haven't joined me before, just at the outset, I will have you out before 1 o'clock. I usually have about a 45-minute lecture with 15 minutes for questions, and then I'll have you out by 1 o'clock. If you do have any questions, I've got the Q&A box open in front of me. I'll try to answer those questions as we go along, but if I'm not able to do that, I'll deal with it at the end, and I will give you some time at the end of the session to ask me some questions. If you don't know me, I am a partner at Lerners, and I specialize as an arbitrator, and I provide advice to counsel on arbitration matters. I'm also an arbitrator at Arbitration Place. And I do a blog, which many of you have heard about, www.arbitrationmatters.com, and it provides a summary of cases, arbitration cases from across Canada very soon after they're released, with some commentary to help tell people what's important about the case or how it fits in generally to the case law. And you can subscribe to that blog for free. I issue newsletters by email every second Tuesday, and I post new stuff on the website several times a week. So let's start with what I'm going to cover in today's session. So this is part 2 of the 10 mistakes that I see in arbitration a lot of times. I started out in the last session, which you can see on YouTube, the seat of the arbitration. What is it? A concept that's often difficult to understand for people who don't have an arbitration background, such as litigation counsel who are doing the arbitration. The important differences between appeals and set-aside applications, and the award versus the order. Lots of confusion there, in part because the terms are not defined, but they have real significance in arbitration law and practice. This session, I'll cover why does it matter whether the Domestic or International Arbitration Act applies. I see in a lot of case law that this issue is troublesome, and sometimes there's a conclusion that it doesn't really matter, and I'm going to suggest that it does matter in most cases. The inherent jurisdiction of an arbitrator versus the arbitrator's power to maintain the integrity of the arbitration. Admissibility versus jurisdiction, again, concepts that are very often confused. The dangers of some shortcuts to save time and money. Arbitration is often chosen for its speed and efficiency, and it can be done without sacrificing due process. So I'm going to give you some examples about things not to do that will sacrifice due process and are perhaps short-term thinking in order to reduce costs, but may not really serve clients' interests in the long term. Failing to participate, failure to object, waiver of rights. Counsel creating an arbitrator disqualification risk. I don't think that's something a lot of counsel think about, and it's something I think about every time I get a contact from counsel asking whether I'm interested in an appointment. Counsel not taking advantage of the benefits of arbitration. As you can tell from these sessions, I'm a real advocate for arbitration, and I'm hoping that if there's anybody here who's not yet on board, my sessions will help convince you that you should consider it for a lot of litigation, considering the backlog in the courts. I'm going to dive deeply into a lot of these issues, and I'm going to use as my reference mostly the Ontario legislation and the model law. Ontario primarily because it's the act that I'm familiar with, and it also means that I'm more likely to be able to answer any questions that you may put to me in the Q&A box. So the first issue is, why does it matter whether the domestic or the international arbitration applies? So let's set the stage for this. The Ontario Arbitration Act says that the act applies to an arbitration conducted under an arbitration agreement unless the act is excluded by law, or the more common reason is the Ontario International Act applies, and that act adopts the model law. So the Domestic Act applies unless the International Act applies. So when does the International Act apply? It applies to international and commercial arbitrations. So it must meet that two-pronged test. First, an arbitration is international if the parties agree that the arbitration, if the parties' agreement at the time of the conclusion of that agreement. So the determination of whether the arbitration agreement is international is decided at the time the arbitration agreement is signed, not at the time of the dispute. And at that time, their places of business are in different countries, or one of the following is situated outside the country in which the parties have their place of business: the place of arbitration, or the seat, any place where there's a substantial part of the obligations of the commercial relationship is to be performed, or the place within which the subject of the dispute is more closely connected, or the parties have expressly agreed that the subject matter of the arbitration agreement relates to more than one country. And so if the parties haven't explicitly stated in their arbitration agreement that the place of the arbitration is explicitly set out, then you can see why that's an issue that needs to be determined by the arbitrator, and why there might be some analysis required in order to determine that issue, which may complicate the determination of whether the arbitration is international or commercial or domestic. The second requirement is that the arbitration must be commercial, and there's no definition of commercial. So you take a look at the notes to the model law, which says that the word commercial is to be given a very broad interpretation. It actually provides a really long list of kinds of disputes that may fall within the definition of commercial. This is not very often litigated, but one example of a case that's well known, I'm sure, to all of you, where this issue was debated is the Uber case. The Uber case can be cited for so many arbitration principles. So if you're not familiar with it, you really do need to read it. But so here the parties didn't agree which act applied. They did agree that the case was international, but they couldn't agree that the arbitration was commercial. So the issue made its way all the way to the Supreme Court of Canada on the stay motion issue. So Mr. Heller brought a class action against Uber. Uber brought a motion to stay that action on the basis of the arbitration agreements among the various class members. And the plaintiff, Mr. Heller, took the position that he was permitted to proceed with his litigation because the arbitration agreement was unconscionable. And in fact, that's what the Supreme Court of Canada held. But the court also considered whether the Domestic or International Act applied, and concluded that employment relationships, and it concluded that Mr. Heller's relationship with Uber was whether that was an employment issue was included in the definition of employment, which was an excluded relationship under the International Act. And so although it was clearly commercial, a debate about whether Mr. Heller was an employee or not was not commercial, and therefore the Ontario International Act applied. And for those of you that are thinking about all the potential ramifications of the Uber case, the issue was the stay issue was decided by the Supreme Court of Canada because it found that the arbitration agreement was unconscionable, and therefore the whole issue didn't go to the arbitrator under the competence principle. So why is it important that you understand the differences between international and domestic legislation? So number one, the default number of arbitrators is different under the model law than it is under most domestic acts. So under the model law, the default number of arbitrators is 3. So if the parties don't stipulate that under the arbitration agreement, the model law provides that there are 3 arbitrators to be chosen. Under the Domestic Act, it's 1. And this may be very important to the parties because in international arbitration, it's not uncommon for parties to want to have a representative on the tribunal who understands their legal culture, and so is able to bring that to bear and ensure that the tribunal has that background. Or it may be important that the tribunal has a particular area of expertise among its members. And so that may be a reason why in domestic arbitration, parties may want to have and choose three tribunal members. But the standard, if there's no agreement, is one. I'm going to tell you something that may surprise you if you haven't heard the statistic before, but when you're considering whether you've got the option to choose a sole arbitrator or a three-person tribunal, I've often heard that the arbitration costs of the arbitrators are 5 times greater where there's a 3-member tribunal than when there's a sole arbitrator, which can be attributed to the fact that the tribunal members are not just working on their own, but have to consult with one another and deliberate. So that's another factor that you might consider, along with obviously the size of the potential damages in the dispute. So the number of arbitrators is different. The form of the arbitration agreement. Under the model law, the arbitration agreement shall be in writing. And this is very important because that's a requirement under the New York Convention, which means that the arbitration or the award may be enforced and recognized under the New York Convention. Very critical. Under the Domestic Act, the arbitration agreement need not be in writing. And so oral arbitration agreements qualify, but you can imagine that because an arbitration agreement is nothing more than a contract, if a party is relying upon an oral arbitration agreement, there may be the same problems that would ensue in proving any other contract, which is that proving the certainty of terms or even proving that there is such an agreement will be much more difficult if it is not in writing. Another difference between the domestic and international acts is appeal rights, which I reviewed that in the part 1 of this session. Under the model law, there's no appeal rights. There's no ability for a party to argue that the arbitrator made an error in law or fact, or that the arbitrator got it wrong. The parties may only seek to set aside the award on the basis that there's been some unfairness in the process, the arbitration process. Under the Domestic Act, there are rights of appeal, and those rights are very different. So this is another example of the necessity to read the legislation carefully, the legislation of the seat, to make sure that you understand your client's rights. In BC, there is a right to appeal on questions of law only. In Ontario and Alberta, there are appeals of questions of law with leave, unless the parties otherwise agree, and the parties may agree to allow appeals on questions of mixed fact and law and fact alone. So the test for leave differs significantly as well. The stay motion test differs under domestic and international law. Under model law, there is a referral of litigation to arbitration unless the arbitration agreement is null and void, inoperative, or incapable of being performed. And a very easy place to find a definition of each of those terms is in the Petrowist case, the Supreme Court of Canada decision of 2002, SEC 41, which stands for a lot of different principles as well. But it provides that null and void means that the arbitration agreement is invalid from inception. So, for example, a party was under an incapacity and incapable of entering into an agreement. Inoperative means that the arbitration agreement has ceased to have legal effect by way of frustration, discharge, waiver, the fact that the parties may have entered into a new and superseding agreement. And incapable of being performed means that the arbitration agreement just can't be implemented. And a good example of that is a pathological arbitration clause. So those are the grounds under the model law. Under the Ontario Arbitration Act, there is a shopping list of reasons why a stay may not be granted. And those ultimately, I think, amount to the same thing as the model law grounds, but they're articulated differently. So a party has entered into the arbitration agreement while under a legal incapacity. So the arbitration agreement doesn't exist, and the stay will be denied and litigation allowed to proceed. The arbitration agreement is invalid, and we know what that means from the Peace River decision. The subject matter of the arbitration is incapable of being the subject of arbitration under Ontario law. The motion was brought with undue delay. And whether there's been undue delay as a matter of fact and circumstances, and the court faced with that argument will have to make a determination on those facts, or the matter is a proper one for summary judgment. And this latter requirement is a bit of a head scratcher. There are cases in which a party has succeeded in fending off a stay motion on the basis that the matter is a proper one for summary judgment, but the party hasn't brought a summary judgment motion as part of the hearing. And so the courts will, surprisingly, make a determination, very few, and the issue doesn't arise very often, but may make a determination that the matter is a proper one for summary judgment, while other courts will say, I can't make that determination without having the summary judgment materials before me. So the safest course of action, if you are making this argument, of course, is to bring your summary judgment motion at the same time as this stay issue is being debated. Another difference between the domestic and international law is the test for disqualification of an arbitrator. The model law talks about circumstances existing that give rise to justifiable doubts as to the arbitrator's impartiality or independence. And that's called the justifiable doubts test. And we see that in a lot of rules. For example, the ADRIC rules use that test. The BC Domestic Act uses that test. The Ontario Domestic Act talks about a reasonable apprehension of bias. And the courts seem to treat the two tests as the same, although as far as I'm aware in Canada, that issue has never been discussed. It's been applied from the analysis, and an example of that is the Jacob Securities Inc. against Typhoon Capital BV case, 2006, Ontario Security Court, Superior Court, 2006, and the Aroma franchise case, which everybody's talking about, 2022 Ontario Superior Court 6188. And I'm going to be sending you a list of all of the cases and legislation that I talk about after this session is over with links, so you don't need to take notes. And I think those cases certainly suggest that the two tests are the same, but there hasn't been a definitive determination. And I would argue that the Aroma case actually creates some confusion about that. And that case is actually going to be heard by the Court of Appeal in early December. There are some similarities between the two acts, and they're important similarities. The arbitrator duty of independence and impartiality, an absolute requirement that you'll see in all of the Canadian legislation, and it's a worldwide standard. Parties are to be treated equally, and fairly. Some legislation doesn't talk about equally, but all parties must be treated fairly, and parties must be given a reasonable opportunity to present their case. The set-aside application requirements under the model law and the Ontario Act are comparable. Sometimes the language is not exactly the same. Similarly, the requirements as to a form of award and the correction or interpretation of an award. That language in the Ontario Act, certainly, and the model law is not exactly the same. But the concept is that the parties have an opportunity after the award has been issued to seek corrections or interpretations or clarification of the award if they see fit, and there is an open issue about whether parties are required to do so before they can appeal or seek to set aside an award, and the current case law suggests that that's not necessary. So the next issue is the inherent jurisdiction versus the power to maintain the integrity of the arbitration. And it's well accepted and seems obvious when we consider the origin of the arbitrator's jurisdiction that there is no inherent jurisdiction of an arbitrator in the same way that there is of judges in courts. The jurisdiction arises simply as a result of the parties' consent as reflected in their arbitration agreement. So the arbitrator's jurisdiction arises solely because the parties have agreed that it will. That jurisdiction, however, can be very broad and expansive, and will, of course, be subject to a proper interpretation of the agreement. But the question is, what does the arbitration agreement say? And what do the rules governing the arbitration say? And what does the law at the seat of the arbitration say? Clearly, it includes a broad power of the arbitrator to decide procedure, subject to, of course, the agreement of the parties. So where you might see that power limited is arbitration agreements which say that the arbitrator does not have the power to order damages other than direct damages, or the arbitrator does not have the power to award injunctive relief. But what this allows, this broad jurisdiction allows the arbitrator to keep the process moving and not get bogged down by disagreements as to procedure by the parties. They hire the arbitrator because the arbitrator is the expert in the process and is charged not only with ensuring that there's an enforceable award at the end of the day, but ensuring that the process works, that there's no there are no unreasonable delays. And so the broad powers of the arbitrator facilitate that. So you'll see, for example, in the legislation, this broad power reflected very simply in the Ontario Act. The tribunal may determine the procedure to be followed in the arbitration. Under the BC Act, subject to this act and any agreement between the parties, an arbitral tribunal may establish proceedings and make procedural orders for the conduct of the arbitration proceedings. Under the model law, the arbitrator has the power to determine the rules of procedure and obviously has the evidentiary power to admit, determine the relevance and materiality and weight of any evidence that's brought before the tribunal. Sometimes this power results in a more interventionist or activist tribunal than new counsel or parties to arbitration expect, because they often view the arbitration agreement quite narrowly. But if you consider the purpose of arbitration and why people choose arbitration, the broad powers that are granted to the arbitrator are consistent with the party's fundamental rights to fairness and with charging the arbitrator with control over the process. So it's not uncommon for the arbitrator to be very active in asking questions and not just sitting back and letting the process unfold. And there's I think a really helpful case called Dufferin against Morris and Hirschfield, 2002 Ontario Superior Court 3485, in which a party sought to have the arbitrator disqualified on the basis of reasonable apprehension of bias, on the basis that that party viewed the arbitrator's conduct as far too interventionist. And the court actually said, no, this is an arbitrator who did exactly what he was retained to do by ensuring that the process was controlled and moved forward in a way that ensured that the parties were heard equally. So I think that's actually that case is really worth a read. But there's a question about what additional powers the arbitrator may have, and there's not a lot of guidance for that. So arbitrators who kind of move beyond that certainly put a toe in the water, but clearly the arbitrator has the power to give effect to the arbitration agreement by fulfilling the party's clear intention to arbitrate as set out in their agreement. So if there is a party that is clearly flouting the purpose or intention of the parties expressed in their arbitration agreement, the arbitrator has the jurisdiction to weigh in and try to rectify that. However, the scope of that power is not clear. And as I want to emphasize, that's not an inherent power that arises from the party's clear intention to arbitrate. So how might those powers be used to prevent an abusive process, to ensure a fair, orderly, and efficient process? How about some case examples? It may include the authority to exercise control over counsel, but be very careful because counsel are not party to the arbitration agreement. So sometimes this will involve sanctions against parties for the conduct of their counsel. And of course, arbitrators will want to be very careful about that. Or another situation that I've heard discussed is a party will retain new counsel in the middle of the hearing, which counsel has created a conflict that didn't otherwise exist. And an arbitrator will have the jurisdiction to prevent a party from engaging that counsel, which flies in the face of the clear duty and right of parties to choose their own counsel. But there's pretty much consensus that an arbitrator would be able to step in on that basis, because that would essentially bring the arbitration either to a standstill or create chaos. Another example is where the rules or the parties' agreement do not specifically allow for a summary process like summary judgment. And so if the arbitrator determines that the arbitrator has jurisdiction to entertain a summary judgment motion and determines that this might be an efficient way to bring conclusion to the arbitration at less costs, the arbitrator may decide that he or she has the jurisdiction to entertain a summary judgment motion. There's a case called Optiva against T-Bell, 2022 Ontario Court of Appeal 646, which says that a summary judgment motion does fulfill the requirements that parties be entitled to full hearing and due process, because a summary judgment motion achieves due process. And that shouldn't be a surprise given what we see in the court proceedings about summary judgment motions. All of these powers that can be implied from the party's intention to arbitrate are consistent with the objective that the arbitrator's job and the party's objective is to provide the most efficient, least costly resolution of the dispute. The next topic, admissibility versus jurisdiction. This is an often confused distinction, and it's a really important one, and one that the arbitrator must understand, or risk a challenge to the award because the arbitrator doesn't have jurisdiction. So most often this issue of admissibility or jurisdiction arises where there's a multi-tier arbitration clause. So an arbitration clause that provides for negotiation or mediation before arbitration. And so the question often becomes, how is that arbitration provision, clause provision to be interpreted? Does it deal with an admissibility or jurisdiction issue? It sometimes arises in a claims process that you see often in construction clauses, where there are steps to be followed, or construction contracts, where there are steps to be followed before arbitration may be implemented. This is an issue of contract interpretation often. Did the parties intend that there be negotiation or resolution or a step before the parties were permitted to arbitrate? And so, if so, is this a precondition, a requirement before the right to arbitrate arises, or is it an expression of the party's hope that this is a desirable process? Again, that's a question of the interpretation of the arbitration clause. The issue really goes to whether the arbitrator has the power to decide the dispute, which is an issue of jurisdiction, and it's a question of law. Where there's a clear negotiation mediation requirement, that it's a condition precedent to the arbitration, this is an issue of jurisdiction. The parties express an intention that negotiation or mediation must, rather than may, take place before any party has the right to arbitrate. So the consent of the parties to arbitrate is conditional upon the completion of the negotiation mediation stage of the process, the dispute resolution process. The arbitrator has no jurisdiction to act until the conditions precedent are either fulfilled or waived, just like a regular contract clause. If you're interested more in multi-tier clauses, I did an earlier session about this, which you can see on YouTube. How is jurisdiction dealt with if it's raised by a court, by a party? It can be raised as a preliminary issue under either the model law or the Ontario Act, or it can be dealt with after the award is issued. If it's dealt with as a preliminary issue by the court, by the arbitrator makes a ruling. Any party dissatisfied can take the issue to the court to, quote, decide the matter. And there is no appeal from that decision of the court. If it's raised as part of an appeal of an award, then the regular appeal or set-aside processes apply. But the arbitrator must be right on the issue of jurisdiction, which is why it's a question of law. The arbitrator's opinion doesn't matter. That's why a supervising court will make the determination afresh. You see this in the Russian Federation against Luxtona case, 2023 Ontario Court of Appeal 393. And the principle harkens back to the leading case of Mexico against Cargill, 2011 Ontario Court of Appeal 622. So it's a question of law. The arbitrator must be right. Now, in reality, courts are reluctant to interfere with a court's jurisdiction decision. That's just the reality when you take a look at the case law. So it's difficult to show that the arbitrator lacked jurisdiction. Admissibility, very different concept. This is a question of whether the arbitrator will or should exercise the power to hear the case. Is the case, as it's currently structured, defective in some way? And this is a question of procedure. So if the drafting of the arbitration clause about whether the preconditions are required or not, this will invariably be interpreted by the arbitrator and the courts as a matter of admissibility. And this, of course, is consistent with the public policy view that arbitration should be promoted. The question is whether the case has been brought prematurely. That's what the arbitrator will consider. If the parties express an intention at the time of the contract to try to resolve the dispute before the arbitration, but what they've invoked are various non-mandatory provisions, which mean that no party is prejudiced if the settlement or negotiation stages are not successful from bringing an arbitration, this will be considered a matter of admissibility. Or the non-mandatory options are not fulfilled and the parties are not required to have them fulfilled before they arbitrate. Or the claims are not yet ripe. And this is the example of the construction contract that I talked about, where there's a requirement that there be a notice of claim filed with a response, and there's a whole process that must take place before the arbitration is fulfilled, but there's no requirement that arbitration follow those. That's just in the contract as it's been interpreted by the arbitrator. That's the desirable route that the parties have chosen. And so admissibility is a procedural issue. It's not jurisdictional, which means that if parties are not happy with this decision, it's not one that can be appealed at the time. It must be dealt with at the end, either by an appeal or because of in a set-aside application. A really interesting case that raises an issue people may not have thought of: Cruikshank Construction against Kingston, 2022 Ontario Superior Court 5704. A limitation period defense is an admissibility question. So even though it raises a question of law, it's an admissibility question because it forms part of the defense, and a defense on the merits does not undermine the arbitrator's ability to make decisions about jurisdiction. So if this is addressed as a procedural issue by the court, as I've said, it's not something that can be addressed until the final award is issued. So what's the significance of this distinction between jurisdiction and admissibility? If the issue arises as parties disagree about whether the matter is to be heard by the courts or the arbitrator, so we're talking jurisdiction or admissibility, it may give rise to various kinds of court proceedings. So firstly, the arbitrator may decide to stay the arbitration while some of these non-required preconditions are tried to see if the parties can resolve the matter. But if not, a party may go to the courts to seek to enjoin an arbitration which has already been commenced. Or if the arbitrator won't proceed, has proceeded, the party may bring a motion to stay the litigation in favor of arbitration. Sorry, if a party litigates instead. There may be opposition to the enforcement of an award if there is an issue about whether the matter was jurisdiction or admissibility, and there may or may not be an appeal depending upon whether the jurisdiction decision is a ruling or an award. So any ambiguity about this can actually put the parties in limbo, which is the very reason parties should be drafting a clear arbitration agreement. And you'll know that in a previous 2 sessions, I've talked about what are some really essential factors to consider when you're drafting an arbitration clause or defending it if it's challenged. There is a really helpful paper that is on the Canadian Journal of Commercial Arbitration website and written by Professor Josh Carton on multi-tier dispute resolution agreements and how they're enforced or not enforced by the courts. And in this context, I think it's very, very helpful because it talks about the issue of jurisdiction admissibility more broadly, and talks about when courts tend to make decisions based on language of the arbitration agreement and public policy considerations. The next topic I'm going to discuss is the dangers of some shortcuts to save time and money. So parties often, or usually, choose arbitration because they want to reduce costs or speed up the process, or both. And all of these are consistent with the parties' interests and the purpose for which they've engaged an arbitrator. So if the parties simply mimic a court proceeding in their arbitration, they're not achieving those objectives. However, parties and counsel need to be very careful about how they create a process that will move faster without sacrificing due diligence. Due process. So number 1, parties should really seriously consider about whether they're going to forego transcripts. If there's no recording of the proceedings, it can be very difficult if somebody wants to preserve rights either to an appeal or to a set-aside. So the parties may contract out of an appeal, but they can't contract out of a set-aside. However, it can be very difficult to prove the necessary facts to sustain a set-aside application without a transcript of the proceedings. There are a number of cases in which parties have had that very challenge. Christie Building Holding Co. Limited against Shelter Canadian Properties Limited, 2021, Manitoba Queen's Bench, 77. Aquanta Group against Lightbox Enterprises, 2022, Ontario Supreme Court. The parties wanted to use the arbitrator's notes, which the court provided was not on because of the arbitrator's deliberative secrecy. You can imagine that the notes may not be just a recitation of what occurred in the proceeding, but could have notes and commentary. And Benke against Nickel, 2023, Manitoba King's Bench, 82. The court simply could not consider an appeal because there just was not sufficient evidence without a transcript. So if parties don't want a transcript, what are some alternatives? Do you really want the arbitrator to take notes? So no record at all of the proceedings. This will perhaps distract the arbitrator from hearing the case, assessing witnesses. Arbitrators may wish to take their own notes for their own purposes, but having a transcript, for example, along with that is very helpful to make sure that the arbitrator has a correct understanding of the facts and the legal arguments. And you can imagine a situation in which the parties are relying upon the arbitrators to take accurate notes if there are 3 members of a tribunal who have inconsistent notes on some evidence or what occurred. So I say not a great solution. What about having an audio recording? And that presents some of its own challenges, of course. Who's in charge of it? Should it be an objective person? What if there's a recording problem? How do parties deal with that? Who has access to it? Is it really practical if you've got, say, a 2-week hearing? It may work fine if you've got a 1 or 2 day hearing where it's easy to go back through the recording and find places that evidence you wanted to listen to or argument you wanted to listen to. So there may be a logistical issues, although I know recordings are very common and they are certainly less expensive. So think about whether that works in your case. Another problem that we see that can affect the ability of parties to take the award further, is a lack of formality in the hearing. So if this is a time-saving measure or a cost-saving measure, really consider the implications of that decision. For example, a failure to mark or identify exhibits. How challenging will it be to bring an appeal, for example? What about asking the arbitrator for summary reasons to save time and costs? Now, there is a debate about what a reasoned award should look like. And that's becoming a more important issue as time goes along, because there are more challenges to awards than ever has been the case historically. But parties are entitled to sufficient reasons, even if they're summary reasons. If they're insufficient reasons, that's a reason to challenge the award. But if reasons are summary, does that jeopardize the right to an appeal or a set aside? There are a number of cases where people found that parties found that the decision to ask for summary reasons jeopardized their ability to take exercise further rights. Nolan against Ramirez, 2020 BC Court of Appeal 274. Alvarez against Alvarez, 2021 Alberta Queen's Bench 717. And the award was abbreviated, but the arbitrator said if the parties are prepared to pay additional cost, he was prepared to provide greater reasons. So think about the consequences of that kind of a decision. There are also process decisions that you can make that affect whether reasons are provided or not. Baseball or final selection arbitration, where the arbitrator must choose between the proposals brought by or offered by the parties. There is an interesting case called 1150 Alberni Limited Partnership against Northwest Community Enterprises, 2021 BC Supreme Court 2053, in which a dissatisfied party brought an appeal and an application to set aside an award in a baseball arbitration, which of course is a challenge, because even if reasons are requested, if the reasons must comport with the ultimate offer made by one party or the other, there could very well be challenges and difficulties with the reasons in those circumstances. So a better solution for parties looking for a shorter, less costly arbitration is to simply choose expedited rules and shop around. It's possible to use the rules of an institution without having the institution administer the arbitration, and find rules that you think will meet your standards and your requirements. Failing to participate or sitting on rights or waiver of rights is another challenge that parties sometimes have when they're trying to reduce costs. And what I'm talking about is failing to object at a time, or even failing to show up at a proceeding. The legislation provides for the requirement to object within a reasonable amount of time, or that party will be deemed to have waived rights. And there are a couple of decisions in which the waiver of rights has been clearly expressed, although the party may not have appreciated the significance of it. Van Hoff against Blocker Limited versus Blankhoff and Blocker Acquisition Court, 2021 Ontario Superior Court, 7211. The party refused to participate in the arbitration or even sign the terms of the appointment, didn't attend the hearing, and found that there was an award made against that party. And the party's excuse when it challenged that award was that it had been advised by counsel that it wasn't necessary to attend. Very scary if you're counsel and advising parties on this kind of issue. In the international context, UMS Solutions against Cornell, 2023 BC Supreme Court 2014. The party brought an unsuccessful motion to dismiss a BC action which enforced a New York judgment for failure to participate in the New York arbitration. So there were 3 proceedings that the party failed to participate in: the arbitration, the application before the court in New York to confirm or enforce the award, and then the application in BC to enforce the award. And there was a reason provided at the outset, which was family illness, for not participating in one of the stages. But the set aside was dismissed because of all of the opportunities that the person had to participate and the failure to do so, notwithstanding that the party said again, he'd been given advice from counsel that there was no reason to participate in proceedings taking place in the US, and all he needed to worry about was proceedings in Canada. Notwithstanding that, he didn't participate in the Canadian proceedings, but that was the first time he actually sought to set aside the award. Not something you or your client want to deal with. But those are examples of the kind of clear and unambiguous conduct that constitutes a waiver. The next potential risk is creating arbitrator disqualification risk as counsel. And what I'm talking about is the very first contact that counsel will make to an arbitrator to determine whether the arbitrator has availability or is an interest in taking on the appointment. And the way those communications often go is a phone call. Hi, it's so-and-so calling. Are you interested in, do you have time for that sort of thing? Those conversations are fraught with risk because of the obligation of the arbitrator to be impartial and independent. And so if that call takes place by counsel for only one of the parties, it's an ex parte communication, which could later create issues. And often these kinds of calls take place because there is a relationship between counsel and the arbitrator. They were spoke together at a conference. They were co-counsel or adverse counsel in a court proceeding years ago. Those kinds of things, they can create risk. The better course of action, and what I recommend, is for an email to be sent, ideally from both counsel, saying, we are considering you, and providing a list of parties and entities to be entered into the arbitrator's conflict search, and that will be names of counsel, names of the parties, key affiliates and representatives, and a very brief summary of what the case is about without any advocacy, and often the arbitration clause. And the reason the arbitration clause is important is because if it contains qualification of arbitrator terms or a provision that says, for example, the arbitrator must be completed within 15 days of appointment, the arbitrator must either accept that or try to get the parties to waive that or change that requirement before accepting the appointment. So that is the safest course of action, and it's something that often parties don't think about or counsel don't think about when they make a call. For more information about the arbitrator's duty of independence and impartiality and the kind of contacts and relationships that can create issues, take a look at the IBA rules on conflicts of interest in international arbitration, which will be sent to you in the resources. And for interviews of arbitrators where counsel are looking for a 3-person tribunal in particular, take a look at the Chartered Institute guidelines for interviews of prospective arbitrators. Again, that will be sent to you in your materials. And the last topic is failure to make use of the benefits of arbitration. This is kind of a catch-all topic, and one that I've pretty much touched on in a lot of or most of my sessions, because arbitration can really offer a lot of benefits to parties who have a dispute in achieving due process, fairness, with less cost, and certainly expediently. It is very common for an arbitration to proceed from inception to a hearing and award within a calendar year. And those of you who are familiar with working in the courts will be flabbergasted by that. And given the backlog in the courts right now, it still surprises me that more parties are not choosing arbitration. And if parties would really like a judge to make the ultimate determination on the merits, there are still options of getting an arbitrator involved to help cut through some of the discovery issues that usually bog down the litigation, so that the matter gets on the trial list a lot more quickly. So an arbitrator can consider part of a dispute, an interlocutory motion, a discovery dispute, for example, or a summary judgment motion, that sort of thing. Case management, an arbitrator can case management a piece of litigation. When are you going to get your pleadings in? When are you going to be exchanging documents? When will examinations for discovery take place? Are examinations for discovery necessary at all? That sort of thing, so that the matter can proceed very quickly. Get the parties' dispute on the trial list. There will still obviously be a wait after that point, but they've sped through and can get through the pre-trial processes in a matter of months rather than a matter of years, which is the wait time for a number of motions before the court right now. And there are a number of cautions that I'm going to list to you, and I've talked about in all of these sessions, which really are an impediment to having arbitration create those cost and time savings that people are looking for. So, for example, parties want to use the rules of civil procedure or court practice in their arbitration. The only cost and time savings is that you're not waiting around for the court to hear a matter, because the arbitrator is invariably available much more quickly than the court is, and will often hear matters very summarily, sometimes without the need for motion records. But really, if you're going to use the rules of civil procedure, you will end up having a very long process and will not take advantage of a lot of what arbitration can offer. If there is a desire to have kind of the structure of rules, if you're not familiar with arbitration and you really, in order to satisfy yourself or satisfy your client, that you'll have a process that will be satisfactory, choose some institutional rules. And again, you need not have the institution administer, but those will give some structure so that the parties have some expectation about how the process is going to unfold, and not leave it to the arbitrator to make those decisions. Another is failing to appoint an arbitrator that has experience in case management and creating creative procedure. Many arbitrators promote that. I'm one of them, and we say that each case is different and will require a different process. So if that's important to you and you're looking for cost and time savings, choose an arbitrator that you know will look at the specific dispute and create a process that works. And remember that when the arbitrator is creating this process, it is always with submissions of the parties. So if the arbitrator's first idea doesn't work, parties have an option to make some opportunity to make submissions before the arbitrator will make a process determination. There are also other processes that parties can think of that may speed things along, and that are Arb process, which means you build in the mediation into your arbitration process, and you don't have to deal with waiting for both a mediator or switching between processes. You've got a single individual who comes to learn the dispute intimately and the parties' interests. Baseball final offer selection arbitration, which is one I referred to earlier, you can get your hearing and award very, very quickly. A hearing in writing alone. This is in the nature of an application, for example, without cross-examinations. And there are lots of cases in which that kind of in-writing process will work very well and will speed up the final determination. Asking for summary reasons. And again, the dangers of that I've already expressed, but in some circumstances that may make sense. Bifurcating the procedure so that the issue of liability is heard first, and after that it may not be necessary to deal with damages. Perhaps the parties can resolve that. And my final point is not consulting with colleagues who have done arbitration. So if you're shy, if your client's pessimistic, talk to colleagues who use arbitration regularly and find out what they think about it, where they think are the pros and the cons, and build that into the process that you and your clients create. So it's 12:55. I don't see any questions in the Q&A box. As I said, you're going to get a recording of this session and a list of resources that I discussed. For session 12 on November the 16th at 12 to 1, I'm going to really dig into the aroma decision that I talked about, because it really does deal with the duty of the arbitrator to disclose, the duty and the test for disqualification. And the case itself has been subject to a lot of debate. If you haven't heard about it already, now that you've heard the word, you're going to hear it everywhere. And I think it raises a lot of really interesting questions about what the test should be in Canada, and what the circumstances are that should require arbitrators to make disclosure, because this case has affected the disclosure decisions of every arbitrator I have spoken to. So it's really affected practice. Whether it's affected the law, I think, is subject to debate, but it's really affected practice. So it's 12:56. I don't see any questions. Hope this session was useful, and I hope you'll join me for the next session. I've applied for Law Society professionalism credits for that November session. So stay tuned. If that's important to you, stay tuned. I'll have more information about that when I hear back from the Law Society. Have a great day.